Can I proceed, Your Honor? Yes, sir. Okay, May it please the Court, I'm Gary Udashen, and along with Caitlin Gilbert, we represent the applicant in this application for writ of habeas corpus. As the Court knows, we're here on behalf of the Innocence Project of Texas. The issue here is an issue that may be obscure to most lawyers, but it's not obscure to the Innocence Project of Texas and people that deal with wrongful convictions, particularly in the writ process, which is what we do. So the issue, as the Court knows, is whether or not the knowing use and the unknowing use of false testimony by the state at a trial should have different standards of materiality. And this is an unusual posture that we're in because the state agrees with us. You know, what our position is that the standard of materiality, as this court has applied it for about the last 15 years, should be the same for both knowing and unknowing use of false evidence. The state agrees, and as far as I know, nobody's asking this court to change that. But nevertheless, the court has set this case for this issue to be discussed. Now, the reason why I say nobody's asking for the court to change it is because this is really an issue primarily of application of prior precedent, of stare decisis. And we've briefed this very extensively in our brief. As the court knows, I'm going to get into some of those factors in just a minute, but as the court knows, the standard that has been applied and is continually applied, and I haven't studied the hand-down list this morning, but frequently on the hand-down list, there are cases raising unknowing use of false evidence by the state. And the court either grants or denies those and cites Weinstein. The court doesn't go into further discussion because Weinstein clearly sets out the rule that you've been following for quite a long time now. The standard on both knowing and unknowing use is whether there's a reasonable likelihood that the false testimony affected the judgment of the jury. So that's the Texas standard. That's the rule in this court and in this state. Now, the competing rule is the New York standard, which comes from a 1988 Federal Court of Appeals Second Circuit case from Manhattan, from New York, the Sanders case, where they came to a conclusion that there should be different standards for knowing and unknowing use, and they set out a different standard. What's interesting in the development of this area of the law throughout the country is that when this court decided Chabot, there weren't a lot of courts around the country, either state appellate courts or federal appellate courts, that had recognized unknowing use of false evidence as a due process violation. So this court was probably one of the first courts to do that. That was 2009. Certainly since 2009, there have been a lot of courts that have come to the same conclusion this court came to in 2009, is that is a unknowing use of false evidence is a violation of due process and should be something that can be raised on a writ application to set a conviction aside. And so there is a definite trend in the law, and I think it really appears based upon everything going on in the law, that although the Supreme Court has not directly recognized this as a ground for relief, as a violation of due process, they're going to at some point. All the indications is that they're following the trend that everybody else is following. So the question is really whether you apply yes.
I don't want to break your flow, but is Chabot and Weinstein, is our line of cases in this regard, is this a state law basis for relief, or is this an interpretation of the federal Constitution?
I think it's an interpretation of the Due Process Clause.
Okay.
So I think, and what I was getting at, because it does relate to that, what I'm getting at is that there definitely are cases that from other state courts and some federal appellate courts, where they say, okay, we're going to recognize that it's a violation of due process for the state to unknowingly present false evidence, and we're going to apply a different standard of materiality to that than we do to knowing, and they just cite Sanders from the Second Circuit in 1988. Without any discussion or analysis or giving any reason. They just treat Sanders, because it's a federal case from the Second Circuit, as the most important case out in the world on this question. And really, there's no reason to do that, and this court didn't do that. This court didn't just blindly adopt and follow Sanders. This court decided what the standards should be on their own, and really, what I would hope would happen with this is that instead of courts, as they adopt this rule in the future, just saying, well, there's a federal court from 1988 in New York City that said there should be different standards, so we're going to do that. Maybe they should be saying, well, the most reasoned opinions and the court that's had the most experience with this issue is in Texas, at the Court of Criminal Appeals, and this is how they do it, so that would be persuasive authority. Because, I can't say that I've researched this in every place in the country, but I would be willing to bet that there isn't a appellate court, federal or state, anywhere in the country that has dealt with this question as much as this court. And that's a nature of how we handle these cases in Texas. It's a question, and it's caused because we deal with wrongful convictions in a more robust way than most states in the country. So this court should be the court people are saying, well, this is the court that has the best rule because they have the most experience on this. But what it really comes down to is whether or not the rule should be overruled, whether this precedent should be overruled and be replaced with something like the Second Circuit did in 1988. And this is a matter of application of the Lewis factors on whether this is appropriate to overrule stare decisis. And I'll go through those factors, and essentially, and we did this in our brief to a great extent, but every one of those 5 factors weighs in favor of not overruling the precedent here.
Can I interrupt you?
Yes, you are.
So, do you agree that most of the cases where we have addressed this issue, it doesn't matter what the standard of materiality is, but in this case, the judge recommended granting relief under one claim and denying relief under the new science claim, so it would make a difference. Do you agree with that?
I'm not sure that's true. I understand what the question is. I suppose if you overruled the precedent and the standard you adopted in its place for unknowing use was the same standard that is in use on 11073 cases, then it would make a difference. But it's actually not entirely clear what you would do if you overruled the precedent. I suppose you could say we're going to overrule the precedent and we're going to adopt the Sanders rule from the Second Circuit, and if you did that, it's not entirely clear what the outcome would be. I think the only way it would be entirely clear, as you suggest, Your Honor, is if you adopted basically the 1103 standard. That could result in that.
Well, let me ask you a quick question then. On page 23 of your briefing going forward, you say Texas is not alone in applying the same materiality standard to knowing and unknowing use claims. But I haven't looked up all the cases you cited. But are you saying that in these jurisdictions, unknowing use is recognized, or that the same standard of materiality is used in those cases?
Your Honor, we went into our brief and we cited a lot of different states and different federal courts of appeals that now recognize unknowing use as a violation. Right. And then we discussed the fact that most of them that have addressed the materiality standard as to whether it should be the same or different, most of them do have a different materiality standard. And like we said in the brief, most of those cases, maybe even all of those cases, just say we're following the Sanders rule. But Nevada in particular, the Supreme Court of Nevada, which we cite in the brief, has done the exact same thing this court has done, which is apply different materiality standards. So as far as courts in other states, Nevada is in line with what you do.
Different materiality standards?
Oh, I'm sorry, the same materiality standards. But it is true there are more courts that apply different materiality standards. But our point was that I know in one of the cases where there was a discussion, it was either Chavez or Weinstein, the question was raised as to, are we alone on doing it this way? And whether you were alone or not at that time, you're not alone anymore, because at least Nevada is in line with it.
Let's look at Nevada for just a minute. Has there been a question presented to their courts about whether that's a good idea or not yet? Or have they just sort of done what we've done so far?
I don't know the answer to that, Your Honor. All I know is that the case where they said it, and that's all I can say. I presume.
So that would put them really kind of in the pocket of like where Texas is today versus what's potentially a better, if there is potentially a better way of handling things.
Well, I understand. I think I understand where you're coming from on that. I think, this court has applied this unitary standard of materiality for a long time, case after case after case, 15 years or so. And this court doesn't just do things without reasoning and deciding that's an appropriate thing to do. I presume the Nevada court does the same thing, that they make their decision, they apply whatever standard they're going to apply because they've considered the alternatives and whether that's the right thing to do. So I assume that's what we're dealing with there.
Well, I think what Presiding Judge Keller pointed out is that, in the cases that we've handled in the past, it wouldn't have resulted in a different outcome were we to have two different standards, if that makes sense. So when you see a case where it might make a difference, don't you think it's reasonable to stop and consider whether a different standard ought to be considered even? Well,
I'm certainly not criticizing the court for considering the question. That's not my intent. My intent really is to say nobody's asking for a change. The Tarrant County DA's office is not asking for a change. So you have before you the parties here where we're in alignment on what the right answer is. I'm not questioning the court's ability or reasoning for asking for the question to be briefed and argued. All right, thank you.
Thank you, counsel.
Good morning, Your Honor. Stephen Conder on behalf of the state of Texas. As opposing counsel said, this is an odd position that we're in because Mr. Thomas presented multiple claims to the trial court, and we did agree that he's entitled to relief under the current status of the law of how we evaluate claims of false testimony. As Chief Judge Keller pointed out, we did not agree on the 1107.3, and we did not agree on their actual innocence claim. And I can briefly explain why I think those standards are different, or I can go straight into the issue of should knowing or not knowing make a difference. And honestly, I do not believe that the knowledge of the people really makes a difference, because if the issue we have before us was false testimony used to convict a defendant, does it really matter whether or not the people involved knew or didn't know? Granted, if someone did know, if a prosecutor did know, there are all kinds of other things that could happen to them. Particularly, they could be looking for a new position, they could be looking at charges with the state bar. But I think it's is the purpose of this to look at the conduct of the people involved or the actual evidence? Is the evidence that we put before the jury, is that true or false? And so I don't necessarily think that it matters whether or not whether or not the prosecutors knew, and in this case, nobody knew. And I think the court has to understand that this case evolved out of a huge sea change in how we look at DNA mixture cases. As the court is well aware, in 2015, the Texas Forensic Science Commission issued their letter, which advised us that the way we've been evaluating DNA mixture cases was wrong, and that the labs had been doing it wrong because they had not imposed a stochastic threshold to make sure that there were no false negatives or false positives, including the way they present analysis to prosecutors, defense lawyers, and juries in the courts. So this case evolved out of our office going back and re-looking at every case where we did that. We sent out disclosure letters to defendants in close to 200 cases. We agreed to reinterpretations in more than 100 cases. And it went down and went down. In Mr. Thomas is the case where there was a shift in the standards. And it went from he was included on the gun to being excluded from the gun. And to me, that is a very clear change that the testimony that the analyst gave is no longer true. And I will tell you that the way analysts are trained by our labs in Tarrant County have changed because of this action. So this case is kind of a rare duck. And so that is why we're in this very rare position that the state is in agreement on one point of error. But as to on the materiality standards, I agree. The 11073 and what this court has devised in the false testimony are different. And that was an argument this office made to the trial court, was that the difference is the current materiality standard requires no balancing. And whereas
I'm sorry, I didn't hear the last part.
requires no balancing of the evidence, whereas the 11073 standard, we would look at the other evidence. And as this court is well aware, we do not believe that Mr. Thomas is innocent of this crime. Our position has clearly been that the DNA evidence that we used to convict him, we should not have been able to use it, and that needs to be corrected.
So are you saying, so you're not saying that on a regular unknowing use case that we should add in a weighing of the evidence type
Well,
analysis?
I think we look at it in the regular false testimony thing. We look at clearly how did this evidence impact the jury? What did it play some role? Did it do? And I think that was kind of, if we look at in Chavez, that was kind of in that opinion, they went about how we were looking at this point. But if you look at 11073, I think that clearly has an implied balancing test where we're going to look at what other evidence is out there and compared to taking out this one piece of evidence. And so it creates two very different things. One is simply a due process violation where, okay, we look at this clearly had some impact on the jury because it was heavily argued by us. We know the impact that science has on juries. And then we look at, as opposed to like, if we did a pure 11073 analysis, which the state presented to the trial court, which is, if you look at all the other evidence, it doesn't mean there's a reasonable probability the jury didn't know about the DNA, they wouldn't have convicted him. And so I think we're looking at two very different theories, and that's why we tried to split it for the court. It's a very complicated decision because we're really cutting some fine lines there. But if we get back to the original question of the knowledge, I don't think the knowledge really matters. I think it's an issue of, okay, under our current body of law, we have adopted this materiality standard looking at it, and under 1103, we've adopted a different materiality standard. They're very clearly different. And so, and to answer your prior question about the 14th Amendment, I think that is how this court has looked at it as a 14th Amendment issue. I think our office in particular has made some arguments in the past about that, about how retroactive this could be, and this court found that it was all retroactive. So of course, that's not in play in this case because this is a pure post-Chabot case. But it's the state's position that he is an interest of justice entitled to a new trial because we use this evidence that we can no longer use, and that the jury clearly relied upon it, and also the Court of Appeals relied upon it in corroborating the accomplishment of testimony. We don't think he would be entitled to relief under 11073, and we don't think he's actually innocent, and those are the points that we presented.
Why does the law even ever recognize different standards of review?
Well, I think we have to look at what is the violation. I mean, in terms of false testimony, we're looking at something that's a due process. It's a constitutional violation. Whereas like 11073 is purely a statutory, so we have different standards. So we need to look at them differently.
I mean, does that just beg, that sounds like it just begs the question, though. I mean, you're just saying because it's a statute. Well, that's justification alone for a different standard of review. I mean, there's a deeper philosophical question, I think, that I don't know whether either of the parties have addressed it, but I'm just curious about, why do we have different standards of review for different kinds of issues that come before the courts? And why do we have different burdens of proof? And why do we have, for example, rules that require that objections, for example, to evidence be preserved as opposed to not preserved? Because after all, we could all look at the evidence and decide whether it would have been admissible if the objection came in. So why not? Why not just go ahead and, if we think it's admissible, go ahead and just let it in and not require an objection to review that question later on? I mean, we have standards in the law, and I'm wondering, why do we have those standards?
Well, I think these standards are important for, first of all, to make sure that in most cases we only have to do this once. I think, okay, take your example of the objection. We need to do that so the trial court has the opportunity to correct it at the time. If we're going to look at, on an appellate purpose, we want to look at, okay, where did this violation come from? Are we saying that this action occurred because it's in our Constitution, we're going to hold things to a certain standard for violations of constitutional law? As in this case, we're saying that it's a due process violation under the 14th Amendment. Or are we looking at it as purely, something that the legislature's come up, and we're going to look at it's pure law, that there's not a constitutional requirement that you have these processes in play, but it's our legislature has determined that the people of Texas are requiring us to go through these processes.
Well, are all due process violations the same?
On a broader sense, yes, but I think that's why, but how they might impact the case is why we have to kind of have some flexibility with the standard to look at them and go, okay, did this have some impact on the case such that we lack the confidence, or we feel that it had some undue influence on the people deciding the case?
If the state, for example, intentionally runs in evidence that would otherwise be inadmissible because of some rule of evidence violation, versus the state, manufactures an entire case against someone and calls witnesses that it coaches and tells them to lie on the stand and threatens them if they don't lie that terrible things will happen to them and their family. Are those the same? Should they be measured and weighed the same by the courts?
No, I don't think so. And I think well, your second example involves something that's purely like a state basically engaging in not only just perjury, but also engaging in a complete, basically trampling of due process rights versus the, I'm assuming from your prior example, you're saying something that the prosecutor knows they shouldn't have admitted and do so. I think if it's clear that they should not admit something, then they should be run on the same standard. But if it's something that's an arguable point of law, I think there's a difference between myself and the defense saying, I think this piece of evidence is admissible, they're saying it's not, and later the courts tell us, state you were wrong, defense was right, versus someone, myself or some other prosecutor deciding, this is my guilty person, and I'm going to create whatever it is I need to do to get a jury verdict. If the court has no further...
That would not only be a different standard, that would be a crime.
That is
Correct.
also true. That is also true. It would be a
State and
crime.
federal.
It would also be an ethical violation.
So you wouldn't really need a different standard then, because the prosecutor could be prosecuted in one case and not the other? Because after all, there's already another remedy out there for what the prosecutor did.
Well, what I'm saying is I think that, if the standard is, if he violates people's due process rights in that way, I think that's a much more clear cut that case is not arguable whether or not it has any type of materiality. If we've created a case out of whole cloth versus an argument where we have a questionability about its admissibility. And that, I don't think, again, that's why we look at how material was it to the jury, how much effect it had on the jury to determine if it involves reversal. I think what the second scenario you're describing involves something so far beyond that, it does delve into criminality, whereas your first example would not be criminal behavior on the part of the prosecutor, just simply that they were wrong on the law.
I have a question.
Yes, sir.
Mr. Udashen said that even though the Supreme Court has never recognized yet a due process violation for the unknowing use of false evidence. He thinks it's coming. Do you think they will use the same standard of materiality? Or I should ask Mr. Udashen, do you think they would use the same standard of materiality for knowing and unknowing use?
I think that that's where they're going, because we're like, what we're looking at is, I mean, again, I think you have to look at the evidence itself and what the power of the evidence versus the motivation. And I don't see in the law where like whether the prosecutor had good motives or bad motives, or whether they had any motives at all. It's what that evidence impact is on the case and on the jury.
I understand that argument. And how the impact is judged is what we're considering here. And the legislature has said you judge it based on preponderance of the evidence. I guess I'll ask Mr. Udashen the same question.
Actually, I have a question.
Yes, Your Honor.
You, in your brief, you make an argument, and sort of dance around this. Are you suggesting that we need a new standard, that we need to change our law? It seems like you've made an argument for why it is we don't. We don't need to change the standard. We don't need to change the law.
The argument I'm making is I don't think we need to like differentiate between knowing and unknowing, because I think that if we create a system where we discover, because in this case, like in a scientific case where the science has changed, nobody knew the science was changed, nobody did anything wrong, but we still have bad evidence we put before a jury. I think it's easier for that to be remedied if we don't have to say, prosecutor, you did something wrong, or analyst, you did something wrong, when at the time they did nothing wrong.
Sure.
So I think it gives us a useful tool to be able to correct a problem without having a circling of the wagons, and for people to be worried, oh, if we acknowledge something's wrong, then somehow I'm subject to a grievance, or I'm subject to something else. And so I think it allows us a tool to correct convictions that have flaws in a straightforward manner.
Well, the tool is there because we recognize a due process violation in the unknowing use of false testimony. The question is whether the tool is going to be the same as for the knowing use of false testimony. And are you saying that that protects prosecutors in a way because they don't have to admit they knew something?
What I'm saying with the knowing and unknown is that I think I think in terms of its effect on the validity of a conviction, it's the same. I think that there are ramifications that if this court were to find that a prosecutor had knowingly done so, I think there are all kinds of personal and professional things that could happen to that prosecutor, very different than, but I don't think the impact on the actual case differs, because it's still the defendant being tried on evidence that's no longer valid.
Thank you. Thank you. Thank you, counsel.
Your Honors, the question, like I said initially, is really an application of the Lewis factors on overruling precedent. And all of those factors clearly, like we set out in the brief, weigh in favor of not overruling precedent. Let me talk about factor number one, which is that the original rule or decision was flawed from the outset, which I think Judge Keller goes to the arguments that you made in Chavez and Weinstein about why the rule should be different, why the materiality standard should be different. A couple of comments, and we discussed this in the brief, but one concerns finality, and I think it is highly significant that the state here doesn't rely upon a finality argument. And I think what we've seen, as you well know, over the last 20 years in Texas, is there's been a rebalancing of how finality fits into the scheme of important considerations in the criminal justice system. And finality is a consideration, but it doesn't override truthfulness and the accuracy of the verdict. And I think that the idea that finality would be a reason to have different standards, I think this case is a good example of the state doesn't rely upon that. And I think in Texas now, it would actually be an unusual prosecutor that would argue that the court should not consider granting relief on a writ where the conviction is based upon false evidence because finality would trump the fact that the false evidence affected the conviction.
I guess at the end of the, let me just ask you this question. At the end of the day, because you both agree, if there's false evidence presented, how would that put either of you in the position of explaining how did it impact the jury in a different way? If it's false, right?
Well,
if you have a different standard, I mean, how would you ever?
Well,
Do you understand my question?
not exactly, but let me try.
I'll clarify.
Yeah, go ahead
So,
and let me try.
so if you have two different types of false evidence, one knowingly and one unknowingly, and you're put in the position of having to use a different standard for each, how do you ever define how that impacted the jury in a different manner?
Well,
Because it's false at the end of the
right,
day.
it's false. The fact that it was knowingly presented or unknowingly presented, the jury doesn't know. It has no effect upon the jury. Nobody tells the jury the prosecutor did this knowingly or the prosecutor did this unknowingly, so it has no effect at all. I do think it's important also to point out that the two cases where there's been some discussion by this court about whether the standards should be different or the same, Chavez and Weinstein, both of those, the court applying the current law, the current standard, found no materiality. And the court didn't grant relief on those cases. So that really goes to the part of this analysis under the Lewis factors is the current law working? And when you look at, we cited several cases where the court, all these cases apply in the current standard. We cited several cases where the court has denied relief. We cited several cases where the court has granted relief. Nobody could look at those and say, well, this is too easy of a standard for a defendant to meet. Look at what the court did in Chavez and Weinstein, and look at what the court has done in these other cases where they've denied relief. So clearly it's working, which is probably the overriding consideration on whether it should be overruled. And then part of these factors is does it encourage or discourage inconsistency, which I think goes to Judge Richardson's question, is that it would certainly be inconsistent to take the exact same situation where the state knowingly presents evidence, and you take the exact same situation where they unknowingly present false evidence and come to different conclusions based upon what the prosecutor did.
But that's what most jurisdictions do, right? They use different standards. Once they, in the first place, recognize that there is a due process violation, then they use different standards.
That is correct, Your Honor, that most jurisdictions follow that Sanders rule from 1988 and use different standards. What I'm encouraging you to do is to write an opinion that causes them to look at your opinion and follow your opinion rather than the opinion from the New York court.
I don't want to interrupt you talking about the 5 things you want to go do, but I do want to ask, I don't want to forget to ask you the question that I asked the state. You have predicted that the United States Supreme Court is going to eventually recognize the due process violation for the unknowing use of false testimony. Do you have any reason to think that they would use the same standard, or are you just not going to make a prediction about that? That they would use the same standard for materiality for knowing and unknowing use?
Let me answer it this way. I think when and if the Supreme Court recognizes the due process violation for unknowing use, and they look at the Texas Court of Criminal Appeals standard in your cases, and they compare it to the Second Circuit cases following Sanders and other courts, they're going to say your cases are more reasoned and apply a better rule. So
they hold us in that regard, do they?
that's right. Well, I think it's inevitable that if you look at the standard on this issue from this court, it just makes more sense than what the Second Circuit did. And you know, it's a different time. This is not 1988. The criminal justice system is different. Everybody looks at wrongful convictions differently. And my guess would be the Second Circuit, if they had that to do all over again, would do what this court has done. It's just, this is not 1988.
Are there any cases where we've ever followed what New York does?
I hope not. I'm not aware of any.
I have a question.
Yes.
Have you thought much about those jurisdictions that have created different standards? Why did they do so? Do their opinions give any insight into what might be the motivation or the rationale for saying that in one circumstance we're going to apply one standard, in another circumstance we'll apply another?
We have looked at that exact question.
Okay.
And inevitably, those courts over and over again say, we're doing it because the Second Circuit in 1988 did it in Sanders. And that's their reason.
And you're kind of hoping that if we issue the opinion that you're asking us to issue, that then people will do the same thing, but just looking at text?
Exactly. All right.
One quick question. Y'all
Yeah.
filed a motion to supplement the record.
Right.
The record has been forwarded up here. We've already filed it. Do you want us to dismiss the motion?
If you have what we were asking for a supplement of, then dismiss the motion. We don't need it.
Thank you.
Okay. Thank you, Your Honor.
Case is submitted.
Thanks.
All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.